Yeah, that should be better. My name is Bill Bola. I'm an attorney who practices in Doylestown, Pennsylvania. I'm a partner in the law firm of McNamara, Bola, and Panzer. My practice concentrates on land use and zoning, and I've been appointed by the Radnor Township Board of Commissioners to act as hearing officer of this conditional use application. As opposed to the commissioners determining this application, a hearing officer is permissible if that person is learned in the law of land use. And it enables the township to participate in the hearing in the form of its solicitor. So Mr. Rice, who's normally seated up here with the commissioners, is seated now before me because he's going to be entering his appearance on behalf of the township as a party to this matter. I will discuss party status with you in a minute. A conditional use is a use that is permitted under a zoning ordinance if the conditions or criteria of the ordinance that creates it can be met by the applicant. It is not a use that is adverse to the zoning ordinance or at variance with the zoning ordinance. It is not a use that requires proof of hardship or anything like that that you might hear would be necessary with variance. It will be the applicant's burden to prove that the plan or plans that it intends to submit and develop on these properties will be consistent with the ordinance and the conditions of the ordinance. And if the applicant can prove that the plans for development are consistent with the conditions of the ordinance, then a conditional use must be granted. Parties opposed may wish to prove that either A, the use is not consistent with the use and plans are not consistent with the ordinance as it's written, or to present evidence that shows that even if it is consistent, that there is some extraordinary impact of this particular development that would impact the health, welfare, and safety of Radnor Township and its residents to an extent greater than that is assumed by the conditional use that is sought. In other words, a conditional use is like I'll liken it to even a regular use under a zoning ordinance. Let's say a restaurant is permitted in your commercial district by special exception. Special exception and conditional uses are one and the same. It's just who the hearing body is that determines them. When a use is permitted by special exception or conditional use, the impacts of that use are assumed. Therefore, that's why the second level of defense, if you're a party opposed to the application, and if you're not here to prove that they can't meet the conditions, is that there will be some extraordinary impact upon public health, safety, and welfare, not assumed by the use when the ordinance was enacted. Thus far, I am aware that there are two parties to the action. The applicant, who's represented by Mr. John Snyder, who's seated to my right, your left, and Radnor Township, who's represented by Mr. John Rice, who's seated to my left, your right. Now, there is a right of members of the public or their attorneys, if there are other attorneys in the room, to enter their appearance as a party to this matter and stand in the same shoes, essentially, as these two parties. By becoming a party, that gives you the right to cross-examine the witnesses that the applicant may present at the conclusion of their direct testimony, or to present your own witnesses or evidence to prove whatever it is you'd be here to prove as a party. And lastly, it would be clear that if you obtain party status at this level, you'd have a right to file an appeal to the Court of Common Pleas of Delaware County if you would view the decision, my decision, that I will render at the end of the hearing to be adverse to your interests. It will be my practice to hear the thoughts, comments, and to try to answer any questions that members of the public may have at the conclusion of the presentation of the case by the applicants. This is called a quasi-judicial proceeding. Quasi-judicial means it's like a trial. And that means in this particular case that the hearing officer acts like a judge to determine the facts and then to apply the law to the facts that he determines in this case. Although you will have the right to give your comments or ask your questions at the conclusion of the hearing, you may wish to enter your appearance as a party if you're opposed to this application and if you wish to present evidence that would show that the application cannot meet the conditions of the conditional use or that its impact would be extraordinary upon the public health, safety, and welfare. If you're here simply to find out what the application is about, or if you're here to try to understand the application, or if you just simply have some questions about the application, it may not be in your interest to enter your appearance as a party, because you will find that out during the hearing and you'll be given a chance to comment and express your thoughts at the end. If you wish, however, to enter your appearance, I will ask that you come forward, come to the mic and state your name and address, and then each of the attorneys that has thus far entered their appearance is entitled to ask you questions to determine your standing to be a party, that is to say, what are the impacts of this development upon you or your property. So I'm hoping I've made myself clear on that. This hearing, as I say, is quasi-judicial. There is a court reporter to my left. She is taking down every word that I am saying now, and that's the way that this hearing will proceed. Question and answer with one person speaking at a time. I know that's sometimes difficult for lay people, so if somebody's questions are stepping on somebody's answers, I'll slow you down and ask you just to go one person at a time so that she can take you down. Okay. Now, I have pre-marked for receipt into evidence. Oh, the other thing I want to say at the outset. We have identified the potential for 4 future hearing nights for this hearing, and I'm going to ask that you mark these down now. October 17th, October 29th, and November 20th. Now, the only one that is somewhat up in the air is October 17th. Plan on it occurring that night. But if for some reason it gets canceled, because I understand that the Township Zoning Hearing Board has conflicting hearings on the same night, if for some reason it gets canceled, word will get out so that people don't have to waste their time and come over here on that night. But please make sure that you've noted down what the 4 nights that we've already tentatively scheduled. We're going to put, the commissioners have asked me to put more notices in the paper of each of those hearings, and we will do that. But still, I wanted you to know, since you're here and you'd likely to be the ones most likely to come back. Now, in connection with this particular hearing, I have pre-marked a number of exhibits for receipt into evidence as hearing officer exhibits. And they are as follows. Exhibit H01, Hearing Officer 1, is a copy of the July 31st, 2013 application for conditional use approval on conditional use docketed number 2013-CU-05. H02, Exhibit H02, is a copy of an August 29, 2013 supplement to the application for conditional use approval for conditional use 2013-CU-05. H03 is a copy of an August 5, 2013 application for conditional use approval for conditional use number 2013-CU-08. Exhibit H04 is an August 29, 2013 supplement to that conditional use approval, again for number 2013-CU-08. Exhibit H05 is a proof of publication of notice of this hearing in the newspaper. Exhibit H06 is a waiver of a 60-day hearing requirement, and I'll explain that in a moment, which is signed by Mr. John Snyder, the attorney for the applicant. And Exhibit H07 is the same waiver of 60-day hearing requirement, which is signed by a principal of the applicant. In this case, the applicant is ES Roman numeral 3 LP. A waiver of the 60-day hearing requirement was necessary because under the municipality's planning code, which creates this type of proceeding and zoning proceedings and planning and zoning and land development generally within municipalities in the state, the hearing must occur within 60 days of the filing of the application. Because of the difficulty we had in obtaining the dedication of this hearing room and getting these three land use lawyers to have a night off together, we had to schedule our first hearing for tonight, which happens to be, I think, the 61st day. The applicant has waived its right to have its hearing within 60 days in order to accommodate that, and for that we thank you. All right, those are the exhibits that I have pre-marked, and now at this point, anything from counsel at this point?
Just one quick question. What was the number on the July 31st application? CU 20130 what? 07, 05? I didn't.
The July 31st application.
05.
H01 was 05. That's
Yeah,
CU
okay.
05.
And the
All right.
other was 08.
And the other was 08. Now, recalling what I said, assuming it was understandable about party status, is there anyone in the room who would like to enter their appearance as a party to this matter? If so, please come forward. Sir, when you get to the mic, would you identify yourself for the record, please?
Yes, James Edelson, Ettelson, partner at Offitt, Offit, Kerman, Kurman law firm. Here representing the Radnor Taxpayers Association, and would like to enter my appearance.
Very good. Would you state for the record, please, your office address?
Yes, 1801 Market Street, 10 Penn Center, Philadelphia, Pennsylvania, 19103.
And it's the Radnor Taxpayers Association?
Yes, it is. 3 words, Radnor Taxpayers Association.
And is there an address, sir, for that?
Yes, there is, 757 Newtown Road, Villanova, Pennsylvania, 19085.
All right. Mr. Schneider, do you have any questions of this gentleman?
Yeah, do you own real estate?
Do I own real
Does
estate?
the association own real?
Yeah, they have that the address that they are at. Accepting mail, they don't own real estate, no. But they do have the standing they represent. It's a civic association and incorporated as a nonprofit corporation, as a civic association for the community benefit. It'll be composed strictly of Radnor Township residents, either on the board of directors or as members and officers.
Any further questions?
I'm at a loss as to what your standing is as a.
Well,
as a
my
civic
standing is
association.
representing
You're
their
not-
interest as opposed to having all of the residents come in and on their own individually, asking for
The same thing over and over again.
over and over again. Judicial economy.
All right. Do you have any questions, Mr. Wright?
Well, just, is it Mr.
Edelson,
Edelson?
yes.
When was the association incorporated?
It was last week. I don't have the exact, I have the exact date somewhere, but it was last week that they were incorporated.
Yeah, I just think it would be appropriate to have the incorporation documents
Okay,
submitted to the record.
Sure.
Civic associations are certainly permitted to be parties in zoning hearings at this level. So I don't, other than that, I think that I have no issue with this.
Very
That's
good.
fair.
Any further questions or any position, Mr. Schneider?
I mean, I'm concerned about this one because it sounds like it's much broader than the area that would be impacted by this application, so I'm not sure. I'd like a list of,
I think it's fair to have a
Members.
list, too. So I'm going to, I haven't heard an objection. Are you objecting?
I would like to reserve the
Okay.
objection until then. I don't mind them participating until then.
Okay,
If
so
you can put that off.
for our next hearing, which, as you heard, we've tentatively arranged for October 17th, or prior to that time, actually, could you get copies of your incorporation papers, recognition from the Commonwealth in that regard, and the names and addresses of the clients that you represent, and get them to Mr. Rice, Mr. Schneider, and myself?
Yes, and what we'll do is, as it's updated, we'll add to it as the hearings progress, if in fact that's necessary.
Certainly perfectly fine.
Okay.
So,
I'm just going, if it's okay to approach, I'll just leave
Please.
her my card that way.
please. So you're certainly granted party status for this evening and likely beyond.
Thank you very much.
Do you have a
Yes.
card?
All right, was there anyone else? Yes, ma'am.
Hi, we're here this evening seeking party status for the Radnor Conservancy. My name is Ginny Kreitler, and this is Phil Wallace, but we're here on behalf of the entire organization seeking standing.
All right, Ginny, is that K-R-E-I-T-L-E-R?
You're very good, that's correct.
Good guess. And your name, sir?
Wallace is with an I-S, W-A-L-L-I-S.
Your first name?
Philip, one L. And we're both residents of Radnor Township.
And you are here on behalf of whom?
Radnor Conservancy.
And what is the Radnor Conservancy? Excuse my ignorance, I'm from Doylestown, so I don't know. Although I am a Delaware County native, so I should be acceptable that.
We're a nonprofit that was established 10 years ago for the purpose of seeking the preservation of open space and historic features of the township in pursuit of preserving the quality of life here in Radnor.
All right, and folks, are you or is it someone in the organization possessed of your recognition letter from the state and federal governments as to your nonprofit status?
We did not bring that tonight, but we
You
can
don't
get it. We
need
can
to
get
have it tonight, but if
whoever
you could
needs
bring
it.
it for the next hearing on October
Okay.
17th, that would be
Okay.
great. All right, Mr. Snyder, do you have any questions of these folks?
No.
Very good. Mr. Rice? No question. Okay,
Okay.
thank you.
I would also seek standing individually as a neighbor near the Ardrossan property.
All right, what is your address, ma'am?
646 Lakeview Circle, Newtown Square, 19073.
All right, any questions of Ms. Kreitler as an individual?
Nope.
All right, before you leave, Ms. Kreitler,
Yes.
the address for the Conservancy.
We have a P.O. box in Wayne and an office in North Wayne, and I will get that to you.
Okay, because as a party, you would receive a copy of the decision that I issue, so I
Okay.
need to have
All
your
right.
address.
I will get that to you. It's been a while since I needed to actually know the details of that.
Very good. Thank you.
Okay, thank you.
All right, anyone further? Yes, ma'am.
Hello, my name is Leslie Morgan. I am a Radnor taxpayer and resident.
All right, and where do you live, ma'am?
I live at 12 Farm Road, Wayne, Pennsylvania.
And the zip?
19087.
Questions, Mr. Snyder?
Where's Farm Road?
Farm Road is right in front of the last density modification process that the township had just went through.
Where's that related to this problem?
We would have to have a map of the township. I'm up near the Villa Stratford, the 115 Stratford, which is going through density modification right now.
Just to clarify, the Board of Commissioners held a conditional use hearing on a different property, 115 Stratford Avenue, a week and a half ago. So I think Ms. Morgan was a party at that one, since she was a neighbor to that property. But that's what she's referring to.
Okay.
Can
Go
you
ahead.
try to explain to me what you think the impact of this on your property would be?
I think that the processes of the zoning code under density modification need to be consistent, like you were saying to us when you first came in, that consistent with the zoning laws. And I'm here to make sure that has happened after spending 10 months and our own money and our neighborhood association's money on the same process. I'm also a taxpayer for a long time. I understand that the recusal of the board is in part because they're trying to negotiate spending taxpayer money to buy parts of this land, so I am impacted directly.
Okay.
Thank you.
Anything, Fred?
Yeah, I do object to this one. I don't think that she is even potentially aggrieved as a resident.
Okay, you have any position, Mr. Rice?
I have no objection.
Thank
All
you,
right,
John.
your objection's overruled, she'll be
Okay.
received. Hello.
Hello, my name is Colleen Price, and I live at 536 Atterbury Road, right behind a portion of this development. I'm a new neighbor there, and I am actually an attorney, so I I know how important it is to get standing, and I know you explained it to the people who are here, but I want to urge all of my neighbors to come up individually and get standing, because I was party to a settlement agreement in another part of the township, and you do have individual rights. And I think anyone who lives here on Atterbury or Knox or Shadeland or Newtown should come up and get standing as well.
All right, ma'am, could you give me your last name again?
It's Price, P-R-I-C-E.
And would you spell, pardon my...
Colleen, C-O-L-L-E-E-N.
No, Atterbury.
Oh, Atterbury, A-T-T-E-R-B-U-R-Y. And my husband as well, unless you want him to come up.
And that's what post office?
Villanova, 19085.
And you're saying that you're asking for this party status on behalf of your husband, too?
Yes.
What is his name?
Brian, B-R-I-A-N, Price.
Very good. Any questions? Mr.
My only question was, what was the street number?
536.
Thank you. I have no objection.
Okay. No objection. Thank
Can
you.
can neighbors come up later and get standing? Or do they
Yeah,
have
you
to-
can reserve, the neighbors who are here, just to kind of find things out that I
Right.
mentioned before, you can always reserve that right to enter your appearance as a party later on in the hearings.
Right, doesn't cost them anything, so
Doesn't
just so
cost
they know that. Okay.
Okay, anyone else? Okay, very good, thank you, folks. All right, Mr. Snyder, do you want to give a brief opening, or you want to jump right into it?
Just a very brief opening, if you would. This is an application under density modification, which is generally a process by which, in this zone, which is basic 2-acre zoning, an applicant can create lots that are not the same 2-acre cookie-cutter standard development, can cluster, and for the purpose of getting the benefits of that, the township ordinance provides that there are density bonuses that are given for properties that go through this density modification. The unusual thing about this application, as you hear it, is that we like the benefits of the design method, but we are not asking for any bonuses in density, and in fact, the amount of units we're asking to be approved here is somewhere in the neighborhood of half of the units that could be permitted on this site, even under the regular zoning. So this is not a case where you have density modification with bonus density being granted. And with that, I would call my first witness, Edgar Scott III.
And prior to proceeding, one other announcement I forgot to mention. This hearing will go tonight until about 10 p.m. I find that I get a little grumpy after 10 p.m. So, and we'll get a lot of work done by that time. If we're finding that we're not moving along at a quick enough pace, we'll start at 6:30 next time. We'll make that announcement before we leave. Okay? Thank you. And your first witness is?
Edgar Scott III.
All right, please be sworn, sir.
You need to,
And state your name.
Edgar Scott III.
Mr. Scott, the applicant in this case is ES3LP. What is your relationship to that company?
I'm the managing partner.
And do you know who the limited partners are?
I think I'm the limited partner too.
Okay. So you are the principal and the only person involved in that limited partnership?
Yes.
Okay. And what is the relationship of that limited partnership to this piece of property?
It holds an equitable interest in the property through an agreement of sale signed earlier this year.
Okay. And who are the title owners?
The title owners are two trusts, just known them simply as the Montgomery Trust and the Tyler Trust.
And Ms. Boll, I had marked some of the things that you marked as other as hearing officer exhibits as exhibits, I'm using MT for main tract, and I'll use W for Wheeler. Right now, I'm just going to be doing main tract. So I'm going to be starting with MT3. There will be no MT1 or MT2.
Very good.
And I'm showing you what is marked as MT3 and asking you what it is.
This is the title sheet of an agreement of sale between the Robert L. Montgomery Trust and Sidney Tyler Trust and EF3 LP.
And what's it dated?
I'm sorry, dated July 31st, 2013.
And I'm going to ask you to look at the background and then paragraph 1 and ask you whether the property involved in this application is the same property, at least a portion of the property that's in this the property in this application is a portion of the property that's under this agreement of sale.
Yeah, yes, it is.
And if you turn to, as I see it, there are 5 page 43s. Is that correct?
1, 2, 3. Well, I have 3.
Well, look on the backs.
Oh, there's the backs. 1, 2, 3, 4, 5, yes.
Okay. And are each of the signature lines in some one of those executed in those counterparts?
Yes, they are.
Okay. So this is a fully signed agreement.
Yes, it is.
Is it in full force and effect?
It is.
And when I look at Exhibit A, which is the map that is like 3 pages from the back, does it show the Wheeler property at the bottom left and the main property that's part of this application to the center and right?
It does.
And are the descriptions that are attached after that the descriptions of the various portions of the property that are being purchased,
They are.
including the 311 acres that are the subject of this application as the first description?
It is.
Namely parcel 1.
Please answer yes or no when you have an affirmative or negative.
Sorry.
That's all right.
Sorry.
So as you're making this application as an equitable owner,
Yes.
what's your relationship to the seller? The trust?
I'm a contingent beneficiary.
And have you ever been a consultant for the trust?
I have, yes.
Have you been involved in the disposition and development of the Ardrossan estate up until this time?
Yes.
And would you explain to the hearing examiner a little bit of the history so that he can understand what is involved in this piece of property?
Originally, this, if you can see this map,
You're pulling a map over, and is it the same map as marked MT6?
yes? Yes?
Okay, explain what that is.
This map shows Ardrossan Farms, and at the north end and the south end shows what we call Ardrossan 1 or 2. Those were developments or preservation projects that were completed, the northern one in 1997 and the southern one in 1999.
Excuse me, but they've zeroed in a little, so when you talk about the southern one, you need to slide it up
Oh,
so
I'm
that
sorry.
they can see both, or you need to keep it, there you are.
I'll look at it this way.
Yeah.
So the northern one and the southern one. So this was a project that I developed in 1996, 97, and the one in the south here in 99. They were low-density, low-impact preservation projects that were concerned with, the preservation of views, the preservation of historic buildings, and really were the result of an effort to find an alternative to conventional development.
And what's the dark parcel to the west of the main parcel?
It's marked, if you can read that, it says Skunk Hollow. Skunk Hollow is about 90 acres that was part of Ardrossan Farms and was conveyed to the township in about 1970 and is, part of the township open space and park system currently.
Now, it doesn't show very well as yellow, but there are, as I count them, 4 yellow parcels on the site. What are they, on the map, what are they, and would you point to them?
4 yellow parcels?
Yes,
I mean, like this one?
like that one?
That's the Wheeler, we call that the Wheeler Field?
And that's application 08?
Application,
Conditional use
yeah.
08,
Mhm. And this is, we call the Quarry Field?
And that doesn't have an application.
That's correct?
Would you point at that again, please? Very good, thank you.
And then there's one to the far left?
There's 12 acres to the west, which is actually in Newtown Township. So it's not in Radnor Township, it's not a party to anything we're doing here.
Okay, and then where is the other that is yellow?
So that would be this area here.
Okay, and is that the application for 05?
Yes.
And from the standpoint of preparing to develop 05, has ES3LP engaged various consultants?
We've engaged a number of consultants to help us, advise us, from civil engineers, Momney Associates, who's here this evening, to land planners, Lacken, Thomas, and Panzak, to environmental specialists, some landscape architects, and a whole raft of people that have gone into developing this program.
Traffic?
And traffic, of course, yes.
And that consultant is
Help me out.
TPD?
Ah, yes, TPD.
And are those consultants going to be testifying for you and on your behalf in this hearing?
Yes,
And they're authorized to do so?
and they are authorized to do so, yes.
Now, when you looked at developing the main tract, the 311 acres, given what had happened on the Ardrossan 1 and Ardrossan 2, what was it that was your basic criteria that were established for your consultants to follow? What were the things that you are trying to achieve?
Well, we're trying to minimize the number of houses. We're trying to maximize the benefits of preserving views. We're trying to minimize wetlands disturbance, steep slope disturbance, woodlands disturbance. So we're trying, in effect, to leave the land as much the way it is as possible. We said in the beginning, when we were doing Ardrossan 1 up there at the north, that when we were done, we wanted people to still be able to feel like it was what it was like when it was, still one parcel, one estate with a number of different farm clusters on it. And I think we achieved that objective. And again, on the south, I think we achieved that as well. So in trying to come up with a plan for the center 300 acres, we wanted to keep in mind that we want to minimize the ground disturbance, tree disturbance, wetlands, steep slopes, and also to provide an environment where the view sheds, some massively long, beautiful view sheds, can be unencumbered with housing.
On the 311 acres, are the existing estate features any different or any, well, just leave the word different, any different than what
Well,
you
you know,
dealt
one-
with in the north?
There is something that's always attracted me, and that is from the east end of the property over here, from here over to here. According to historical records, that ground was all shaped in 1910. And in the process, a stream was filled in, and this pond that you see now gets its water in from an underground pipe. And when it flows out the other side, then this west end of the property wasn't sort of reconfigured. And so it gives the two halves of the property a very different look. The objective back in those days was sort of in a capability Brown standpoint. You wanted to have a big piece of landscape architecture on which to place a big house. And so the idea of preservation can extend not only from a house or its contents or, you know, from that perspective, but it can also extend to the land that you really can't shape like that anymore. It's not a environmentally possible thing to do. But the views are very sort of park-like, long. The contour of the land is very pleasing to the eye. So we wanted to try and have a plan which captured the benefits of that earlier sort of landscape architecture.
Now, did you consider 10-acre lots or 2-acre lots as a concept in trying to develop this property?
We've considered just about every concept under the sun. We did look at, 10-acre lots because they were very successful in Ardrossan 1, so successful that we were able to reduce the density by about 50% when we got to Ardrossan 2. But laying out 10-acre lots just was really not really all that kind of a desirable product for the whole 300 acres. So we had to try some different things that ranged from various kinds of clusters to some clusters, some 10-acre housing, some, different variety. And ultimately, we discovered from an overall planning standpoint that we could have a few houses that had really spectacular views. We call them kind of beachfront views. And, when we discovered that as an aesthetic, we realized that what we were looking to achieve fit, quite nicely in the density modification ordinance for Radnor Township. And so when we discovered that, we began to work towards making this presentation tonight.
So you're familiar with the density modification provisions in the zoning ordinance?
Yes.
And did you find the goals and guidelines for designing under density modification to be consistent with those personal goals that you had just enumerated?
Yes, I did. Mm-hmm.
In addition, on that base 311 acres, are there existing improvements on there that were a factor in your determination of how to develop?
Well, there are. There are clusters, And the clusters, whether they're, up in what we call the Murray House cluster or the dairy cluster, they lend themselves to smaller lots in some cases, or, a variety of lot sizes to accommodate. They range in those two clusters have sort of main buildings that certainly, date to the 18th century.
How about the circulation through the site and the entries to the site? Are there any features there that lent themselves to your use of density modification?
Well, the idea that if with a minimum of density, that, for instance, the main drive, which is such a significant entry point to the property and kind of follow through, that because of the density modification ordinance, we would be able perhaps to keep the size of the road the same if we made it a one-way road. And that would allow us, there's a very extensive wall that runs along Newtown Road to the north, very extensive gates that are, a little narrow if you viewed them on a two-way traffic standpoint, but that's wide enough for a one-way standpoint. And so it would allow us to, keep the historical driveway, the historical planting along the driveway, not lose any trees, and maintain them the way they are now.
Okay, now, the plan, then let's take that off, and let's go to the sheet in front of you is I have as MT4 a 11.5 by 7, 11.5 by 17, I guess it is, or 14 or whatever.
11 by 17.
11 by 17, copy of a conditional use plan that says that it is 38 sheets. Is that the application plan?
Yes, it is.
Okay. And the cover sheet that is below it, is that, or that you have in front of you, is that the sheet 2 of that plan?
It is sheet 2. Yes, it is.
Right, for the record, for purposes of identification, MT4 is an illustrative site plan that 64 lots, compared to the Ardrossan form, by ODMOMNP and Associates Inc., dated July 31st, 2013.
And after filing that plan with the amendment of August 29th, amendment to the application, did you file, or did Mominy file on your behalf 10 revised sheets to that
Yes.
plan?
Yes, I did.
And I'm showing you MT5, and I presume that's what they are?
Yes?
And what I'd like you to do is look and see whether that sheet 2 is in fact the sheet 2 on MT5.
Yes.
So what we're looking at is sheet 2 and sheet 1. Sheet 2 is the one you have up, and sheet 1 is the one below it of MT5. Is that correct?
Yes.
Okay.
And identification, MT5 is an illustrative site plan prepared by me and Associates Inc.,
And the only correction that I would ask that be made to that is that sheet 1 has 64, sheet 2 has 67, has 87. The plans are different, and there's notes on the plan as to why they're different. If you look in the bottom right-hand corner of MT5, you'll see that the first sheet says sheet 1. And then the second sheet says sheet 2. And what you'll see is that these 10 pages are sheets 1, 2, 3, 10, 10A, 11, 11A, 12, 13, 14, and 15 of what was the 38-sheet plan. Sheet 1 of the 38-sheet plan was replaced by sheet 1 of the 10 sheets that came in later. So that the numbers relate to having replaced the corresponding sheets in MT4. Okay? And the difference is that the applicant has filed alternative conditional use plans that I'll make a representation of, so I don't have to wait for my engineer to testify what it is, and then he can confirm that. But in the upper left-hand corner on sheet 1, you'll see a cul-de-sac with 9 lots. On sheet 2, you'll see a cul-de-sac with 25 lots. On sheet 1, on the bottom left-hand corner, you'll see a smaller number of the medium-sized lots with some big lots. And on sheet 2, which I'm pointing to now, you'll see additional lots there. There's alternative ways to develop the two phases that are in the western part of the property. Now, Mr. Scott, in the creation of either the 64-lot plan, that is sheet 1, or the 87-lot plan, which is sheet 2, have you maximized the density on this property?
Oh, no, not at all, no.
Okay. I see areas that are shaded on the plan, that are shaded in green. What are those areas?
Those are required open space under the density modification.
And I see lots on there, is that correct? Like this plan is the 87-lot plan. I imagine if you counted up, you'd get to a number of lots that equaled 87?
Yes?
But yet I see areas that are just open and white. What are those areas?
Those areas are areas that we would like to keep as they are.
Okay. Are they restricted against being developed in the future if they aren't kept as they are?
No, they're not restricted.
This requested conditional use doesn't restrict their future development?
That is correct.
Okay. So if somebody in the future owned one of those parcels and wanted to come in and seek a new conditional use or a revised conditional use to develop, they could do that?
They could do that.
What is your real goal with those areas?
Our goal is to preserve the view sheds. This is a little different model than we were talking about in Ardrossan 1 and 2. But
Let's put that back up again and, for example, look at up in that area.
in the north here, there's I think 16 lots on 172 acres, and our goal was to, from a planning point, was to find an alternative to 83 lot as of right development. And our goal from a marketing point of view was to find like-minded people who wanted to preserve views and preserve historic structures, and that was a very successful undertaking.
Okay. And did you find the 16 like-minded people you were looking for?
I did.
And did they grant conservation easements voluntarily on portions of their properties?
They did.
Okay. On the, going back to what you have here, let's just take the open area in the center of the driveways, yes. What would be the desire there?
Well, again, we're looking for like-minded people who would like to see that viewshed preserved.
Okay. And would they grant an easement on that, or would there be some other way in which they would preserve that if they so desire?
Well, if they so desire, they could grant a conservation easement on it, or they could simply gift the land to an appropriate 501c3.
There's nothing in this application that would require that to be handled that way, is there?
That is true. There is nothing.
But once again, in the past in Ardrossan 1, you found enough like-minded people to make that plan work and end up with preservation.
Yes, that's true.
And in Ardrossan 2, you found the requisite number of people there of like mind to want to buy in and then preserve property.
Well, actually, we set such a good example in Ardrossan 1 that in Ardrossan 2, we ended up with, a 50% reduction in the density from, an average one house in 10 acres to an average one house in 15 acres. So one was so well received that two like-minded people wanted more open space, and were willing to make that happen for themselves.
And in this application, your desire is to find like-minded people that would want to preserve the non-lotted areas. Have you done marketing studies to determine whether you're convinced that those people exist?
Well, yeah, actually, we've talked to a number of people specifically who would like to, join in together to participate in the preservation. So rather than a generic market study, we've tended to go to people specifically who've shown an interest, and that gives us a greater feeling of comfort that that's what'll happen.
So let me try and paraphrase this for you. What you're saying is that with respect to the unlotted areas, your plan is to try to find people who will buy unrestricted property and voluntarily preserve
Yes.
it by the means that are used as either conservation easements, conservation gifts, or so forth.
Yes.
And unlike the area on the north in Ardrossan 1, where all of that ground is privately owned but conservation eased, in this, it's possible that all the open areas would be actually owned by conservancies.
Yes. Yeah. We're hoping the great innovation of this third effort is to give people both the opportunity to own smaller lots and also the opportunity to participate in, preserving open space. It's a much more flexible model for use anywhere, particularly at Ardrossan, and it fits very well into the density modification ordinance of Radnor Township.
Okay. So the issues that we've talked about your particular viewpoints on what you want to see done with the property, those were the instructions that you've given your consultants?
Yes.
Would you look at MT7 and tell me what that is?
MT7 is a list of buildings on Ardrossan Farm on the 311 acres.
And this was part of the amendment that was submitted on August 28th or 9th or whatever that date is?
Yes.
Okay. Mr. Ball, I hate to do this a little bit, but I think I'm kind of required to by the requirements of the ordinance, but I'm going to ask the applicant to go through and identify all of the existing
Oh, I
buildings.
think you have to. Yes, sir.
Okay, so
And you can use the plan in front of you and just go right down the list by lot number, explain what the building is, and then go to the next one.
okay, M1 is, as it's described here, a 22-bedroom, three-story mansion consisting of 23,060 square feet, accompanied by various outbuildings. You want those?
Yes.
As follows: a garage apartment consisting of 920 square feet, pole barn garage structure consisting of 810 square feet, kennel consisting of 779 square feet, garden storage shed consisting of 160 square feet, electrical vault consisting of 70 square feet. So that's the main house and outbuildings.
Let me stop you right there for a second. Are you the equitable owner of that 10.22 acre parcel?
I am not.
Are you required by your agreement of sale to include it in this application?
Yes.
And so you're authorized to file on behalf of that lot as well?
Yes.
And that lot is not a separate existing lot as of today, is it?
No, it is not.
Go ahead.
Okay, the next on the list is 2.5, semi-detached, two-story twin house consisting of 3,392 square feet, which is here, to be converted to a single-family residence. Should be a great single-family residence, by the way. And then 2.9 is the twin of the twin, semi-detached two-story twin house consisting of 3,392 square feet to be converted to a single-family dwelling. So that would be this house here. Also a great stone residence. 2.10 is a single-family, three-story, eight-bedroom detached house known as Murray House. That would be located here. This is kind of a unique federal design house. It's square. It's three-story square house with a flat roof, consisting of 7,740 square feet to be, well, it is a single-family dwelling, so it'll continue to be so. 2.11 is a single-family, two-story, three-bedroom detached house known as Ivy Cottage, which is adorable. It says that it's to be converted to a single-family dwelling, which it is already.
And what's the size?
It is 1,845 square feet. 2-12 is the garage office apartment right here, which is a 1.5-story building consisting of 5,160 square feet to be converted to a single-family dwelling. 4.9 is a single-family, three-story, three-bedroom detached house consisting of 1,492 square feet. I think that's that one, right there. But there are also two white tenant houses that go along with it that are not noted on this list. And then 410,
Well,
oh, I did that backwards.
let me interrupt you there. You say there are two white tenant houses that go along with the single-family. What's proposed to happen to those?
They'll remain as they are.
In other words, they're not, are you talking about having 3 residences there or 1?
One principal residence and 2 tenant houses as they are now.
Accessory to the principal residence
Yes.
for use by the owner's guests, et cetera.
In-laws, guests.
Okay, thank you.
I made a mistake. This one, 4-9, is the 3-story, 3-bedroom detached house consisting of 1,492 square feet to be converted to a single-family dwelling. And this 410 is the single-family 2-story detached house consisting of 2,000 square feet to be converted to a single-family dwelling. And 410 has the 2 little white houses along with it. 5-1 is a single-family 3-story, 8-bedroom detached house known as Hickory Hall with detached garage apartment, with the house consisting of 8,217 square feet and garage apartment consisting of 1,400 square feet to be converted to a single-family dwelling. 5-2 is the dairy barn consisting of 20,285 square feet to be converted to a single-family dwelling. And 5-3 is a farmhouse and office apartment consisting of 4,939 square feet to be converted to single-family dwelling.
Thank you, Mr. Scott. I'm going to reserve the right to call Mr. Scott back after the other witnesses to wrap up with any other issues that come up, but for now, those are my questions of this witness.
Very good. Mr. Rice?
Just a couple questions for Mr. Scott. Mr. Scott, the agreement of sale that's been marked, that indicates that the ES3LP has an agreement of sale for everything but the main house and the 10 acres that it's proposed to be sit on.
Yes?
Correct? So the main house is going to stay in the ownership of the trusts?
Yes.
Does do you know whether the trust intends to preserve the main house going forward?
I don't think that the trusts plan to do that.
But it'll stay intact on the 10 acres as a separate lot, is that correct?
Yes.
The 2 prior preservation subdivisions that you did, in both of those cases, there were easements granted by the property owners to a 501c3? Is that-
Conservation easements?
Yes.
Yes.
Okay. Who holds the easements from those properties, do you know?
The Brandywine Conservancy?
Okay, on both on both of those.
Ardrossan 1 and Ardrossan 2.
Okay.
Yes.
And you talked about the main road access to the site. The plans proposal at this point is to leave that as is, and to have that, is it currently a one-way road going in, the main road?
It's currently used as a 2-way private drive.
But the proposal on the conditional use plan would be to make it a one-way road in and maintain the integrity of the road and the plantings that are along it. Is that right?
Yes, exactly, yeah.
And the open areas that Mr. Snyder asked you about, as I understand, those open areas, correct me if I'm wrong, the concept is the buyers of these lots would then also buy some of those open areas, with the goal being for those buyers to gift those open areas or to put easements on those open areas. Is that right?
Yes.
Would all of those open areas be purchased by just homeowners that would buy the building lots on this plan?
You know, there's no reason based on the structure that we're using, there's no reason why somebody who was just interested in preserving open space and wanted to, you know, participate and make a gift, there's no reason why that couldn't happen,
Whether they live on the property or not?
whether they live on the property or not.
So the purpose of that gift then for somebody that would buy a vacant piece of property would be for some tax benefit, is that correct?
Yes, there are tax benefits that go with that kind of gift if properly done.
And is it your intent to preserve or to leave intact all the homes that you just described, all the existing buildings and structures there?
Yes.
And who would do the conversion? Would that be whoever buys the lot? Would that be a buyer that would do the conversion?
That would be a buyer who would do the conversion, yeah.
And would there be some standards applied to the buyers?
There
in terms
would
of
be
the conversion?
reasonable, like, you know, there are architectural guidelines actually in the conservation easements of Ardrossan 1 and 2. And so we might have a different methodology, you know, this time as we've evolved. But, you know, we don't want to take away people's creativity, but we do want to know that people are going to either build something new that's in keeping or renovate something that's existing and old that's also in keeping.
Okay, but I mean, for example, the Murray House is 7,700 square feet. So if a buyer wanted to buy the Murray House, it would be on its own separate lot, correct?
Yes?
And would the seller, you being the seller, you would impose some architectural restrictions on a buyer that would buy that house, is that right?
Yes.
Buyer couldn't knock the house down and put up a totally new structure, is that right?
Not unless there was some, you know, good reason for that. I mean, let's be clear, you know, our objective is to preserve these buildings, and we think that the buyers who are going to be interested in these, you know, particularly the old houses, want to preserve them. They like renovating them. You know, it's a fun thing to do. And so that's what we would expect would be the natural order of things. We wouldn't want them to be able to tear it down on a whim, but you know, if there was, you know, some casualty or some, you know, reason they needed to tear it down, you know, those kinds of things.
Okay. And the agreement of sale that has been marked as MT3, that agreement is currently in effect with the two trusts, is that right?
Yes, it is.
And the trusts are aware of the plans that you're presenting here tonight?
They're so aware they're here.
I don't have any other questions for Mr. Scott.
Okay, thank you. Mr. Edelson, do you have any questions, sir?
Just, thank you. Just one. I'm trying to understand a little bit about the white area. The white areas that are shown on the plan, I might call your attention to those. Those are areas to which they won't be restricted. However, you are planning on potentially selling those as lots for preservation. Is that my understanding?
And I'm sorry,
The
would you
white
say that
area,
again?
the white area is shown on the plan. is it my understanding that your plan is to attempt to sell those lots for preservation? They would be part of the investment lots that you were referring to?
My plan is to seek like-minded people who are interested in preserving the ground.
And if, in fact, they purchase those and don't wish to preserve, then what would happen?
Well, that's not the plan, so we'll have to see, won't we?
Well, so assuming we would have to see, and I'll take that as, and I understand that, assuming we'll have to see, then the impact which the township should be considering with regard to this application should include the potential that when we see, we might learn things that we don't know now. Meaning, I can rephrase it if you, if
Well, my objection to that is
Sure.
you're talking about something that would be a future application, which would be in front of the board, because they couldn't do anything with it without having come back here and have those impacts considered then.
But the potential for that development should be, at this point, probably, I mean, again, I'm not going to argue the point with you. I just want to make sure that there is no, we're not committing to preserve that. I think that was how we led off with this testimony.
Obviously, it cannot be restricted, that's
So-
correct.
And that's fine. That was my only question. Thank you.
But we started in the same way with Ardrossan 1 and Ardrossan 2, and, you know, they're preserved today.
And I applaud the preservation. I certainly wasn't demeaning
you.
that. My concern is really that the potential exists, and that was it.
All right, Ms. Kreitler, any questions?
Yes, I have two questions. One's a clarifying question. There's a couple different shades of green and gray on there, and I would love to have you walk us through what the different shades represent. And my second question is just a matter of the traffic study that's going to be redone and the timing of that, when those results will be available.
That'll be a witness at a future hearing.
All right, so address question number 1, if you would, sir.
The easier thing may be that my next witness is the engineer who's going to have the same plan in front of him and will identify what those
Ms.
areas are.
Kreitler, there's a better witness to answer that question.
Okay.
Ms. Morgan, any questions?
I'll reserve till later.
Okay, very good. And Mr. and Mrs. Price, any questions?
My first is an issue, not a question. If we're parties, I'd like to get copies of all the exhibits. It's kind of hard for us to follow along.
Okay, please,
Oh, sorry, we didn't get any copies of the exhibits, and if we're parties, you should bring enough copies so that we can all read along.
You know, I had no idea
Right.
who was or wasn't going to be a
Well,
party.
certainly
so-
more than one. So
Okay,
if you can just
so-
keep it to it, you know, so we can see them as we go.
hold on. What we'll do, Mr. Snyder, please make sufficient copies of these exhibits for the parties who've entered their appearance, and then bring that number of copies to future hearings.
Sure.
Very good.
Okay. I guess I have the same questions regarding the white area in here that's very open-ended. I was at the last meeting, and I believe you testified at the last meeting that you intended to get the people who were buying the 3/4 of an acre lots to buy that. That was the like-minded people that you were trying to. Did you say that at the last?
The 3/4,
You said at the last meeting, didn't you say at the last meeting that the people up in the 3/4 lots, you thought that they would, or the people?
These?
Yes, or the people on the other side would purchase that open land because they would want to protect their views? That was your plan? Isn't that what you
these
said?
people,
Yes.
yeah.
Okay, so that's your plan, is that somebody who's going to buy a 3/4 acre lot with a house on it is going to put up another $500,000 to buy a view shed? Is that your plan?
Sounds like a good plan to me.
I would think that that's not a good plan for someone who couldn't afford that, who would buy that property, to buy that land. So I think when you're talking about like-minded people, have you identified any like-minded people who would want to buy any of this land and conserve it?
Yes.
Can you tell us who they are?
Well, no, I couldn't possibly tell you who they are. But, you know, what I've been trying to say tonight is that, you know, this is an evolution since we started this. You know, we did successfully sell, you know, 10-acre parcels and larger, 10 to 15-acre parcels to begin with, to people who, you know, wanted to preserve the view sheds that were associated with them that you can see if you drive down Newtown Road or Abrams Lane or Church Road. So you can see the view sheds that have been protected. And we're just using a different format. You know, the goal of the like-minded people is in a little bit of a different format to enjoy the same, you know, preserved view sheds.
But wouldn't you assume that someone who can buy a 10-acre, multi-million-dollar lot certainly has more money than someone who's going to buy a 3/4 of an acre lot?
Well, I think one of the things, I'm not sure that we should be talking about the actual dollars and cents of the program, but I would say that one of the major benefits of this program is that, you know, these parcels are more affordable, and so therefore you know, they're open to, you know, a broader breadth of market.
I agree the properties
So-
are, but how much land do you have in the white areas? And can you identify, in particular, say this area? I mean, is that over 20 acres? I mean, how much in the white acres, I'm going to guess, is it about 50 acres?
Well, you know, okay, so inside the drive, this loop
Right,
is 30 acres,
okay.
okay? So there are 3 lots here. They're each about 1.25 acres. And so, and then there's some green space between the common drive and Newtown Road. So there's probably 25 acres, let's say, south of those 3 lots. And that 25 acres is the view shed for those 3 lots, and also the view shed for these 3 lots, and the view shed for these lots over here. So when you're talking about, you know, preserving what, where, you know, all of these people would be interested in preserving their view sheds if they're interested in that kind of thing. What we're trying to do is to have a process where, you know, that's possible in the same way that it was possible for like-minded people to come together and preserve all the land that doesn't contain the houses the first time we did this.
Well, how much?
Excuse me a second. Mr. Bola, I think we're into a discussion that is inappropriate because it's not, it's the planning of what happens to the property that's not being approved for development, which right now is, our plan is, it's not restricted. It's going to get sold to people. What those people do with it is up to them. And more importantly, their intent in buying it, whether it may be bad to have testimony from somebody who's actually not that person saying, well, that person's buying it to protect his view shed. Well, that may affect what he can and cannot do with it, and we're putting words in that person's mouth here. This is all speculative testimony about the intent.
But it is relevant cross-examination.
But
brought
it's,
it up on
but it's
direct.
about the intent of the buyer, not about the intent of Mr. Scott. And Mr. Scott can't talk to the intent of the buyer and shouldn't talk to the intent of the buyer in something that is as sensitive as creating gifting of conservation easements or property.
However, we are talking about the development of this parcel of ground into a number of units. And I think probably what the concern is, are we talking about more units here, or are we talking about
This-
dedicated view
this-
shed, open space?
Neither. We're talking about areas that are neither restricted against future development nor required to be conserved or anything else. They are just areas that are not being approved for residential development and not being restricted against residential development. This applicant has said He hopes to find people that are of a mind that they'd like to buy them and preserve them. And that's all he can say. That's his intent. We can't go into what those people actually might do with them, and nobody can do anything with them unless they file a subsequent application for a subsequent conditional use
Right.
to change it.
I'm going to have some questions about that if some of these folks don't ask before that. So right now, though, if you're objecting, I'm overruling the objection. You may continue.
Okay, you brought it up that this is your plan. So what do you think that property is worth if you expect these 9 property owners to buy the, what is it, 50
That I
acres?
object to is irrelevant.
Well, yeah, that's,
Well, he's gone through this whole idea. He couldn't do 10 acres, he couldn't do 2 acres. He's talked to everyone about what the property's worth. What is 50 acres in the prime center of Ardrossan worth, roughly? $50 million? You think 9 houses are going to buy?
I objected to that.
yeah, it's sustained.
Why can't I ask him what he thinks the appraised value is? He
Because we're
said
not
he-
here to talk about the appraised value. We're talking about use, number of units, use of land.
I agree with
So-
you, but he's telling
so-
us, or wanting us to believe that he has like-minded people, which would be 9 property owners buying 50 acres
Right.
to preserve it. And I think it's ludicrous, and I
Well, the
think
price
everyone
doesn't
agrees.
matter. So it's, I mean, these people are either going to make the price or not make the price if his plan prevails. That's not important to me as hearing officer. I'm interested in how the land is going to be developed.
Okay, well, maybe that's my question, too, on density modification. The way we got our legal notice, you said we've got 311 acres, and you're going to get up to 87 acres. To me, that means those...
87 unit.
87 units, you're done. You tell me what you're doing on all 311 acres. Either the legal notice is wrong, or there is absolutely no ability to add any more units in there. Because that's what we were told. So now when I'm sitting here, it looks like if I've got 50 or 60 acres, and we heard somebody interject before, there's a possibility of putting about 160 units in here. You could put 160 units in there, and I think by approving this, piecemeal, and we get these one-way roads, and before you know it, now we just keep, piling on top, that's the
This is
issue.
your opportunity to ask questions of the witness. You can close later.
I agree, but I'm asking, I think, very pertinent questions, and I think,
And I told you to go ahead.
okay?
So let's ask questions.
Okay, so I'm going to ask you, would you agree to put any conditions on that open area, that it could not be developed into more than 10 acres total, regardless of what you do, what a buyer's intent? What would you give us as a restriction on that land?
The open space has a value, right? So if you want to pay the value of the open space, that's a conversation. It's probably not appropriate to have it here, but that's a conversation that we can have. There are a lot of people who are very interested and very committed to this concept, but, and I, invite you to, call me and go for a tour.
I would like to.
We didn't fall off a turnip truck yesterday. We've been doing this for a long time.
But I did a conservation easement on my property, and I didn't charge the township for it. I gave up my right to develop, and I just did it
I'm
because
not-
it was the right thing to do. So I
I'm
think I do have a
not
right
charging
to
the
question.
township anything for it either.
You're charging $11 million for that corner portion.
Well, that's land they want to buy.
I think that's part of why there's a deal here and why we have a hearing officer rather than the Board of Commissioners, because there's something about pushing this through so that the township can buy that piece of land. So there's a little bit of a conflict of interest here.
Ma'am, this is your opportunity to ask questions.
I understand that. I'm
Please
coming
ask
here
questions.
as an attorney, and I'm also coming here as a
This is
neighbor with...
cross-examination, though. This is not a chance for you to argue. You would not be given a chance to argue in a courtroom, and you're not be given a
I-
chance here.
I'm coming
Please
in
ask
also as a
questions.
neighbor. I'm asking him, would he voluntarily give me any restrictions on this land? That's my question.
You can answer that, yes or no.
Well, it depends on what restrictions you're asking for.
I'm asking for a density idea that you would not go lower than X amount of lots.
I don't
Regardless.
really know what that means. I mean, you can think about it. There's 3 more.
Mr. Bola, the application specifically says that there's no restriction on future development. The answer to that is in the application.
Well, would there be an issue on the number of units that could be developed in this I don't know what to call it at this point, vacant space that would exceed the number of units permissible under the density modification conditional use application?
You mean the 87?
Yeah,
Or the
no,
one-
that
The
permitted.
100 and, when Mr. Fiorello testifies, he's going to testify as to what the maximum could be.
Right.
Certainly, we couldn't go over the maximum because there's no ability to get approval for over the maximum.
Okay, but if you're saying we're not going to be able to put ideas in a buyer's mind and we're not going to say what a buyer's going to do, are you going to say that there can be no more than the number of units permitted under the ordinance, no matter who buys?
You know, we want to maintain any buyer's donative intent.
Well, that doesn't answer the question.
No.
I get that. I
Okay,
understand that.
So then, how, you know,
If you found enough like-minded individuals
Yeah.
who are inclined to either buy a lot and donate or conserve, great, or apparently you're going to market these lots, although they've not been identified as lots, you're going to market some piece of ground, I guess, for that purpose, that's great. But what I think the members of the public are concerned about the number of units that you intend to yield off of this property totally when all of this is done.
For residential purposes.
Yes.
For us, we have our application, 87 to 64, somewhere in that range. That doesn't mean that somebody that buys an unrestricted parcel can't come in for their own approval of it. My concern, very simply, because the tax code it generates some very interesting arguments, is that even if we simply said, we agree to a restriction that you can't get any more units on this property than the zoning code would allow on the property, which is in fact just simply a fact. I know that there's an appraiser out there that's going to say that affects value and it reduces it. And so that person's gift is valued less. And that's why my answer to you and to everybody has got to be that we cannot accept any restrictions on it because of the effect that it may have on those people that we hope buy it and donate it.
Okay, we've got an answer, continue to ask questions if you have any more.
I have lots of questions, but I don't know if I should direct it to you.
Well, then, let's do this. If you have lots of questions, it's my practice to try to give a court reporter a break after about halfway through, and certainly I could use one too. So let's take a 5-minute break at this point.
this open space. So they it's 319 and 5 weeks. But who gets the 319?
I gotta get a little water. We'll wait.
We're on.
It's so confusing.
Okay. Okay, and is there any agreement with the Board of Commissioners or the Township? Do they have an option agreement with you? Is there an agreement of sale to purchase this land?
No.
Is there any kind of indication from them that they'll get this approved if you let them buy the land for 11 million?
I wish there was, but no.
There's nothing.
Is this on?
Yes.
There's nothing like that.
Are you going to have any, like a trail at all on the property? I'd heard something about that'd be open to the public.
No.
There's no trail even on the township portion that they might buy?
Well, that would be the township portion if they bought.
Okay, you're not aware of it? Because I had heard that there might be a trail through the whole property.
I've heard that the
Okay.
township and I think the township is interested in buying, and I think they plan paths and things like that on portions of the property that they would buy. I've heard that.
But would you entertain it in the whole 311-acre lot in any type of development?
No.
Okay. When you did the lot area, if I understand, or I guess really don't understand density modification, the usual minimum is 2 acres in this zone.
Under the agricultural conservation
Right.
district.
So how did you get .7 acre lots up by Newtown Road?
If you read the density modification ordinance,
Mm-hmm.
it explains exactly the methodology for doing that.
Well, I mean, I read it and I thought you could get maybe like a 14% increase, which to me, I don't know if you take the 14% off of the 2 acres and get down to 1.7 acres.
Mr. Bola, my next witness is going to testify as to the density charts and the various options, so maybe that would be a better question for that.
Okay.
Yeah.
Would
That
you?
density thing, by the way, is about increasing the number of units.
Right.
Or increasing the amount of open space.
Right.
But we're not anywhere near the maximum number of units, so that's not something that affects us.
You know what, if we could, as a group, get that in writing, if you would say that in writing, I think that would help us a lot. But I think you could still be there, and I think that's the issue, and that's why I'm asking you these questions.
Okay?
Also, you said you went through the density modification code. It says it's supposed to permit dwellings that are closely related to the physical characteristics in harmony with your surroundings. Now, you've been through Ardrossan a lot. What would you say is the most homes have what kind of acreage out on Newtown Road and in that general vicinity?
I don't understand your question.
Well, would you say that the houses there have about a minimum of 1 acre and a third? The houses on Newtown Road? The houses on Atterbury? Have you been through that? I mean, it's right next door. What would you say, if you drove through there, would you say it's lots of 3/4 of an acre lots there?
I mean, I imagine that there's a variety depending on the existing zoning.
Well, across the street, you have 10-acre zones, right?
There's no 10-acre zoning in Radnor Township.
No, you have 10-acre homes
Yeah.
by lot across the street.
Mhm.
Do you know that behind you in Atterbury, if I told you that it was 1.3 acres, would you agree that that's about right?
I honestly don't know. So I have no basis to agree or disagree with you. It is whatever it is.
So you've been here all these years and you're not quite sure if this is a densely modified, dense area of 3/4 an acre zones? 3/4 an acre properties or more like 2 acres, 1.5 acres? That's your testimony?
I'm not sure what your question is. You know, Brook Farm on the other side is 3/4 an acre you know, I
Well,
know
Brook
that.
Farm wouldn't even get standing. I mean, it's not even near here. I'm asking you specifically
It's
Newtown
literally
Road.
It's literally is almost adjacent to the north end of Ardrossan.
I'm
It
asking
almost
specifically
abuts.
on Newtown, all along here,
Uh-huh.
sizes.
I honestly don't know. Can you tell me?
Yeah, you just showed us on the plan, they're 10 acres.
I think the question's been asked and answered that
I
he
agree.
doesn't know.
That's fine. Well, because it says in here that you're supposed to encourage the development of, similar to, in harmony, what's in your neighborhood. We don't have three-quarter an acre houses on Newtown Road. Newtown Road is 1 acre, 2 acre, 1.5 acre, 10 acres. So it's a very small, it's a big reduction from what's in harmony, what's here. And I'm wondering if you read that portion of the density modification code.
I assume so. I've read the whole density modification code
Okay.
a lot.
Okay, and I also, when you showed I understand you're trying to preserve the wall, which is beautiful, I agree with that, but can you widen that road that's coming in off of Newtown Road?
What road?
The access road off of Newtown that's coming in, you testified to it earlier, off of Newtown to go to those three-quarter of an acre lots.
The three-quarter, are you talking about these lots?
Yes, right there.
And this road?
Right, is that a one-way?
No,
How about this road?
this is 2A.
I thought that was a one-way road when you,
Would be one way.
that's one way.
So we don't have to, so we can keep its historical significance.
Can you widen it at any other portions?
This
After
one?
you come into the entranceway?
We're trying to minimize impervious surface, like roadways. We're trying to minimize stormwater management, the amount of water flowing on. So and we're trying to be in tune with the historical aspects of the property. So if we make this a one-way road, then hopefully it's wide enough as it exists, and therefore the historical aspect of the property will be maintained, and also the amount of impervious surface won't be increased, so the amount of stormwater runoff won't be increased. And those are all good goals from our perspective, and hopefully from the communities. You know, there's minimizing stormwater runoff is a big problem, you know. Anywhere you can do it is a good idea.
I thank you. I think that's a great idea. I think that people are concerned about safety, so maybe that's something you just want to consider. If you have a one-way road, it might be very difficult, for a fire truck to get in if someone's on that road. I did have a question for you, too. On these lots right here, is it possible to move the road in front of them rather than put it here? Can you move the road, the access route to here?
I think if these lots have a wonderful view to the west, they might want to maintain that view. So maybe they wouldn't want to have the road on the other side.
Well, I would ask you for the neighbors, this is our backyard, and we would prefer if the house is backed up backyard to backyard. Is that something you would consider?
I can't even see through the woods that are owned by Ardrossan to the private drive, much less onto the houses off of Atterbury. I can't even see through the woods.
What we can see from your side, so I'm just wondering if you would consider that.
I don't think we would like to consider that, no.
Have you taken any trees down along that roadway here?
I have not, under my agreement of sale, I have not, but I understand in the ongoing management of the farm that there were a number of trees that were dead that were recently taken down as requested by some of the residents on that private drive.
Can you just tell me how many? Do you know how many? About 10 trees, maybe?
I do not know. Somebody bandied about the number of 15. But But, you know, as I understand it, they were taken down by a Raider Tree Service, a reputable local group who we and others use on a regular basis. They were taken down at the request of residences on that private drive. And as I understand it, the trees were dead and needed to be taken down for safety reasons. That was the reason for the request.
Would you replant over there? So that the whole idea was to preserve the trees and to keep the buffer zone, would you replant those trees?
We believe in the natural reforestation that occurs there. When you take out dead trees, the younger ones will grow up. That's a normal part of the process.
So you will not put trees back up there?
I mean, I haven't been given I haven't seen that there's a need to do that. As I said, I can't even see through the woods to the private drive, much less, you know, across to Atterbury.
Well, I'm
So-
saying we can see from your side, and you seem to have taken trees down that were required. You know, the whole idea is to keep a tree buffer in. So I'm asking if you would
Mr.
consider
Examiner,
replanting that.
Mr. Scott said he didn't take them down, that he's not involved in that under his agreement of sale, that it's the ongoing management of the property. These are questions for somebody other than him.
It's not really relevant to this hearing, and I've heard enough about it.
That's fine. I just think it would be relevant if the trees have to be maintained. If 15 trees have been taken down, when you go to say, let's preserve the trees, you've just lost 15.
Depends on how many other trees are around.
I agree. I just want that to be on the record so we can find out why the 15 trees came down. Okay. And you may have already covered this, but when you're talking about the houses that are there, sometimes they have a restriction, like you can't change the facade or the size or tear down. I was a little confused. Are you putting any kind of restriction like that? Are you saying only in the event of casualty that they could rebuild? Or could you kind of clarify what you meant about the?
You know, we're interested in the preservation of the existing structures. Their age ranges, you know, rather dramatically from the early 1700s
Right.
on, so it would probably be appropriate to take them on a case-by-case basis, given their age.
Would that be part of your conditional use application? Would you have, like, architectural standards that we could look at per property that would be part of this?
Is that part of your plan, to have any preservation standards for existing structure?
We would like the structures to be preserved, but we would like to give people, you know, some creativity in how they do that. So there are not a lot of them. You know, we kind of thought we could do that on a case-by-case basis, since I said some of them date, you know, to the early 1700s. So we don't want to force preservation where it's not appropriate. And, you know, frankly, we haven't analyzed the buildings yet. So, you know, we don't know beyond the fact that, you know, we're putting each building where appropriate on its own lot, so that they can become single-family housing as we listed before. And I kind of think, I'm hoping that that complies.
Well, I mean, even in the main house in particular, would there be even just?
The main house is not part of my agreement.
Okay, so there's no restriction on that at all? I mean, part of your agreement, I know somebody may have other ones, but you don't have any restrictions on the main house at all?
I have no restrictions on the main house.
Okay. And there are nothing that you know of that someone would file a deed restriction that says you can't tear it down, you can't change the facade without going to, you know, one of our boards, that type of thing?
I'm not aware of any restrictions like that.
Okay. Are you selling any of this property or planning to sell any to the Radnor Conservancy?
I would be happy to sell land to the Radnor Conservancy if they would like to buy it.
Can they buy the 50-acre interior portion for you for over $1?
For how much?
Objection.
Would you be interested in selling that?
Objection.
Yeah, Ms. Price, this isn't a negotiation, this is a hearing. let's
It's
ask.
also a quasi judicial hearing, and I think that's what people are here. We're trying to figure out what's going on with this interior portion, and I think we're doing everything to sidestep it. And if we would get to that point, either the legal notice is wrong, and you can have more than 87 units here, or I'm only talking about 87 units.
We are
forever.
not sidestepping this one bit. There are areas of this property that are not lotted and are not required open space. They are not restricted against somebody who owns them filing a future application under the then existing zoning. We will not put any restrictions on them because of what they may do to prevent it from actually ending up being preserved. And our application is for up to 87 units and with no restriction on the areas that are not lotted. That's exactly what it is, and so we're not sidestepping it at all. We will not restrict it further because we can't. It is counterproductive to your goals and our goals to ask us to restrict it.
Okay.
Thank you.
And then also in the density modification, you have to have common open space, I think, that is open and viewed by the properties. I don't see how anybody over here can see the common open space. And can you show me exactly what the 15% that you've dedicated as common open space?
Is
where
that
is?
something that's going to be presented
Yes.
by your, yes.
Yes.
Can we hold on that until we have the expert testify, please?
Yes. Okay, thank you.
Okay. To your knowledge, sir, are any of these structures preserved in any historic district in the township? Is there any historic designation on any of these structures?
No.
There is a list of historic buildings in the township. We're not in a historic district, but at least 3 and maybe 4 of the buildings, including the mansion, the Murray House, Hickory Hall, are on that township list.
All right, would you identify those for the next hearing? Just give me
Sure.
a list of what are.
I can give them to you shortly before we end tonight. They're in the comprehensive plan.
All right, because I'm going to want them part of the record, because they will be subject to the ordinances of the township with regard to development and. Right.
Yeah, they're not prevented from being taken down. You just have to file applications for them.
Right, okay. And I know we're going to hear from someone on the open space, but these areas of vacant land that we've been discussing, and the parties have been asking about, are they included within the open space calculations or excluded?
Excluded.
Okay, that's all I have. Next witness.
She was the last.
Brian Price, I'm at 536 Atterbury also. If in like a future drawing, each of your open white spots, if we could just number them and put like how many acres are there? So
Well, we're going to find out from the planner, designer,
Right.
landscape architect next
Right.
about this open space and about the total acreage and so on and so forth.
that's, in layman's terms, how many acres are we talking about where all these plots are now? And how does that fit into the
Right.
modification?
Exactly.
That's it.
We're going to find that out. Thank you, sir. Okay. Yes, ma'am.
Leslie Morgan, I love that idea. Could we also do that for the retained lots, the 11 retained lots, to number them and put the acreage on each of the retained buildings? I don't know what else to call them.
That's on the plan,
In the
isn't it?
plan sheets,
Yeah.
every one of those lots has
Yeah.
a lot number and a size.
It's already there.
Good. You just can't see it up here, and you can't see it on the website.
Well, I'm about to give you,
Awesome.
at the next meeting,
Awesome. Thank you very much.
in fact,
Oh, it's my lucky day. Thank you.
All right. So, next witness.
yes.
Or do you have any redirect?
No, I don't have any redirect. David Fiorella, please. Eddie, look on that list and get the names that are by those numbers.
I do.
Those are the 5 that are on your property.
David Fiorello. I'm a professional engineer with the firm of Momini and Associates in Bryn Mawr.
And Mr. Fiorello, I'm going to show you what is marked as MT8 and ask you what that is.
That is my CV.
And you're a registered professional engineer
Yes, I am.
in the state of Pennsylvania?
Yes, sir.
You have a degree in civil engineering.
I do have a degree in civil engineering.
How long have you been in practice as a registered professional engineer in Pennsylvania?
I'm afraid to say 40 years.
And have you done residential developments in Radnor Township?
Yes, I have.
Have you done density modification developments in Radnor Township?
Yes, I have.
This is not your first with respect to that ordinance.
That is correct.
I'm going to ask that Mr. Fiorello be admitted as an expert in civil engineering and civil engineering with respect to residential developments in this township.
All right, cross on qualifications, Mr. Rice?
I don't have any questions or objections. Mr. Fiorello regularly appears in front of the various boards in the township.
All right, cross on qualifications from any of the private parties? Okay, very good. I will accept Mr. Fiorello as a witness who is permitted to express an expert opinion in the area of civil engineering and of residential developments.
Okay. Mr. Fiorello, would you explain the size, location, existing features of this property?
I think Mr. Scott, in his other plan, had sort of given an overall explanation of Ardrossan. The 311-acre parcel that we're talking about, as shown on this plan here, is basically the center portion of the overall plan that Mr. Scott had shown. It is bordered on the north by Newtown Road, is bordered on the west by Darby Paoli Road. To the south is what was referred to as the Ardrossan 2, and immediately south of that is Godfrey Road. To the north was described as Ardrossan 1, and bordering the north of that is Church Road. The existing site...
We missed the east somehow.
The east is residentially zoned land. There's a private driveway that comes down along the property line that serves a number of houses adjoining that. Atterbury Drive, I believe, which was referred to by some of the other witnesses, is to the east.
Thank you.
And what are the zoning classifications that surround the property?
This site is zoned AC. To the west,
That's an agricultural zone?
agricultural conservation district, minimum 2-acre zoning. To the north, I guess what is shown here as Ardrossan 1, I should note that Abrams Lane borders on the east side of Ardrossan 1. To the west, that is AC, agricultural conservation. To the right is, or to the east is R1. To the right of the Ardrossan main parcel, down to a point where I guess where Ardrossan 2 came off, that is zoned as R1. The area to the south was zoned AC and still is. Below that is the Overbrook Golf Club, which is zoned AC. The Academy at Notre Dame to the west is, I believe, an institutional use. I forget the zoning reference now, but that is not immediately adjacent to this parcel. So we have AC to the north, the west, and to the south, and we have R1 a little bit to the, well, to the east and a little bit in the northeast corner.
Okay, and what are the existing features on the site?
We have 2 stream corridors that bisect the site, shown on the plan here, and I have another topographic plan that I can get if we have any questions about this. Wigwam Run, which is a tributary to Darby Creek. Darby Creek is located on the west side of Darby Paoli Road. Wigwam Run is a tributary which runs, actually it begins right at the entrance road to the site, and it runs in a southwest direction down through, bisects the area of what was called, I guess, the dairy barn and some of the other existing residents. So there's a stream corridor through there. To the south of the site, Camp Run is another tributary to Darby Creek. That forms pretty much the southern portion of the site. A question was raised earlier about some of the shading, and I'm not sure it comes well over the screen, but I have an area which is grayed. We have in the, I guess, the southeast corner, we have some areas sort of in the center. These are woodland areas. These are areas that are already wooded. The green areas on these plans were the areas that we were delineating as open space. But there are several woodlands through here. On some of the other plans, and we do have areas of steep slope that were identified. And I think if I grab I believe it is sheet 5 of the plan set. This is a topographic map of the site of showing the existing conditions. The areas that show up here in brown are areas of steep slope, which are areas of Township looks at steep slopes as areas of slopes 20% and greater. So again, we have tree masses in green on this plan. We have steep slopes in brown, and again, we have our stream corridors running through the site from west. They're running from east to west, but they're pretty much headwaters of the tributaries are in the corners of the site.
Okay, and in studying this site, did you determine the various densities that you could obtain on this property from conventional zoning, from density modification with the base required open space and with the maximum required open space?
Yes, we did.
And I'm showing you MT9. Is that a schedule of those?
Yes. We looked at this, the gross area of the tract as measured to the title line of Darby Paoli Road, Newtown Road, is 311.54 acres. We are, with the density modification requirement, we are required to subtract out the ultimate right-of-way of the roadways. Those ultimate right-of-ways are 6.73 acres. We are required to net out 50% of slopes greater than 50%.
20.
I'm sorry, 20%, you're correct. Floodplains, we are required to net out 50%. I wanted to point out that there are no designated FEMA floodplains on the site. So since FEMA did not designate any floodplains, we did not take that into account. But we came down, by taking these areas out, we came down with an adjusted lot area of 293 acres once we took out all the subtractions that were required. The zoning under AC is 2 acres, and our yield based on 2 acres zoning, just taking that out, not counting the open, well, let me back up. With density modification, you are required to provide at least 15% of the net tract area as open space. We are required to provide a 25-foot buffer around adjacent to properties that are zoned for residential use. So again, because the area along Newtown Square or Newtown Road, east of Abrams Lane, the area to the east, a little bit to the south in the corner here is all residentially zoned. We have a 25-foot buffer that we subtracted out of our area requirements. Based on the required open space, well, first of all, we came with conventional zoning. If you just looked at this, at 2-acre zoning, we're allowed 139 lots. With the 15% open space, you're allowed a bonus of, I'm getting my numbers confused, I apologize. When we go down to adjusted gross lot area, when we divide by 2-acre zoning, we get 146.92 lots, so 146 lots. With the 15% open space, you're allowed a 5% bonus in lot area. So that would give us a maximum permitted lots of 154 under the density modification with 15% open space. With up to, you're allowed another 1% bonus in density for every 3 additional percent open space above 15, up to a maximum of 42. Taking that into account, if we were to provide 42% open space on this site, we would be allowed 167 lots. We're providing 5% open space, so technically, if you work the numbers out, we would be permitted 154 lots. Under the application in front of you tonight, we're proposing 87.
Okay. And the amount of open space that you provided, you said is 15%. Would you explain where and why you've located that?
The intent of this project is to develop the site in phases. There are 5 phases associated with the development. They are shown on sheets 10 and 10A. Again, the only difference between 10 and 10A are the layout of the lots, if you recall.
Is this on Exhibit MT4?
John?
And MT5 is really where your,
MT5 was one of the
has
revised plans.
those sheets.
All right, bear with me here. Mr. Fiorello, you said sheets 10?
10 and 10A, sir.
Gotcha, thank you.
10 again is the 64 lot, and 10A again is the 87 lot plan.
Okay.
The phasing is pretty much the same. They're colored in areas, and on the plans that you have, you can see the phases in different colors. Phase 1 would be this interior area, which on my plan is sort of a rose color. Phase 2 is an area in blue. Phase 3 is a tan color. Phase 4 is the green, and Phase 5 is a brownish color. On these plans, I have shown the open space as a hatch, and these are hatched areas. We've delineated open space pretty much along the stream corridors, some of the more sensitive areas of the site to preserve those. But we've allocated the open space to make sure that we had at least 15% of each individual phase area having that required amount of open space. So if Phase 1 was developed, it has the 15% open space. If that's all that was done, you would still have the 15%. So there's 15% or a little bit more in Phase 2, same with Phase 3 and Phase 4. So each phase will have the required amount of open space as the site progresses.
Mr. Fiorello, I'm going to show you section 28091, which is the common open space section of the density modification portion of the ordinance. Would you read out loud subsection D?
Consideration shall be given to the arrangement and location of common open space to take advantage of physical characteristics of the site and to place common open space within easy access and view of dwelling units, at the same time preserving and enhancing natural features. Areas set aside for common open space shall contain no structure other than a structure related to outdoor recreation use.
Okay. Is there anything in there that says each dwelling unit shall have visual access to open space?
Not as I read it.
Okay. Did you locate these stream cart or open space areas to be consistent with subsection D?
Yes, I did.
And do you think they are consistent with subsection D?
I do.
Are they in the view sheds of the various lots?
They are in the view sheds. Again, the lots were arranged to take advantage of the view sheds. The open space is part of that view shed, but at the same time, the open space is within the stream corridors and some of the more sensitive features of the site, such as slopes and again, the stream corridors.
Okay. Do you have a table in these plans that tells you how much of the area is in building lots, how much of it is in non-lotted areas?
I am not sure I have one. I do recall putting the numbers together, John, but I don't believe I have a copy with me right now.
So you've done that calculation, you could bring that next time?
Yes, I can.
Okay. Did you review areas of the comprehensive plan to see whether the goals of the comprehensive plan are consistent with the density modification goals that you're attempting to achieve?
Yes, as I went through the comprehensive plan, it more or less repeats all the requirements that are set forth in the density modification ordinance.
Are there any specific requirements related to this tract?
Specific requirements?
Is this tract, for example, singled out in the comprehensive plan for some sort of treatment?
The comprehensive plan more or less looked at the area's goals for preservation, conservation, and best practices for the type of development.
Okay. It didn't say on the Ardrossan parcel, this is what we recommend as a comp plan?
No, it did not.
You heard Mr. Scott's goals with respect to site design and preservation of the features on the site. Did you relate those goals to the requirements of the density modification agreement? I mean, ordinance?
Yes, they seem to me like one and the same.
And did you implement them?
I tried my best on the plan, yes.
Okay, why don't you run through the site design features and how you tried to implement them?
Again, we tried to preserve the slope areas of the site. I mean, we can look at this plan here. I've got a number of plans here. The site is so large, the ordinance requires 50 scale plans, which we have in the later sheets. We also have a 200 scale plan to give you the overall view of the site. We have some 100 scale plans that are almost easier to read. But we looked at, again, preserving view sheds, preserving the natural features, slopes. We tried to respect some of the wooded areas. The existing roadways through the sites, we tried to maintain basically because of the, I guess, I don't know if historic is the right word, but the overall lay of the land, and we're trying to respect some of the features that we tried to maintain the existing roads. That's why we're making use of the existing driveway coming in here. This driveway is tree-lined in most areas, and we're trying to work with maintaining, we have proposed the one-way pattern here in order to try to preserve some of the existing feel of the site and, again, try to minimize the earth disturbance and disruption that would be required as part of doing any major improvements, widening of those roads. All the other roads that we laid in here, for example, there's an existing farm path through here that we tried to make use of for our existing roadways. The new roadways in the northeast corner of the site, they're all laid out to work with the topography, so we're not creating any unusual cuts or fills, and more or less we try to maintain with the character of the site a development that was not obtrusive, sort of using the best practices for less disruptive type of development in putting the plan together.
Was it one of your goals to make this development seem like you still were in Ardrossan at the end of it as opposed to in a new development?
Yes, I think the intent was to provide housing units within what is known as Ardrossan now, instead of creating a new type of development built around the site. We're trying to make use of the site as it is and, again, preserve the features instead of moving things around and creating something that just doesn't feel as it belongs to part of the property.
Is there a current development in the reasonable vicinity that you could give that would be a counterpoint, for example, of what would happen if you simply tried to develop consistent with all subdivision requirements lots on this site?
I think down at the other end of Newtown Road, there is a new development coming in where I believe some waivers were obtained, but that was sort of cramming a lot of lots in. There was a lot of tree removals and earth moving, in my viewpoint, to make that happen.
Would the DuPont estate in
The
Newtown
DuPont in
Township?
Newtown Township, I think, is a good example. I think you probably have a site that was maybe an equivalent size. I go by there very often, and it's amazing how much earth moving and tree cutting has been done in order to put something like that up in there. Here
Is it
we're-
recognizable as an old estate anymore?
Not to me.
And is your intent here to have this still recognizable as an estate?
Yes.
While we're on design and compliance, do you meet the area and bulk requirements for the new lots that you're designing?
The area requirements, density modification allows you to modify the size of the lot. You're not restricted to a 2-acre lot size, and it almost gives you, I don't want to say free rein, but it gives you a lot of possibilities to reduce lot sizes in order to work with the land, and in that respect, our lot sizes are compatible. We have on our development plans, and they can probably seen at some of these larger scales, where we have our building envelope shown. We have shown our front yard setbacks measured off the cartway. We have shown our rear and side yard setbacks. So we have shown building envelopes for all those lots, so that those lots, I think we demonstrate on the plan that we can meet all the setback and requirements.
Are there any existing buildings that do not?
Yes, a number of the existing buildings, I think Mr. Scott referenced a number of them. A lot of them, at least, I think 2.9, 2.5, 2.10, those areas there, they were all built prior to zoning. A lot of them are very close to the roadway, so they don't meet the front yard setbacks in those respects.
Okay, and those are listed as non-conforming uses in your plan?
Yes.
And how about
Non-conforming.
Non-
Non-conforming setback.
non-conforming setbacks? How about lots 4.9 and 4.10?
Yes, again, we're showing setbacks on the plans, and those, the other ones that I gave are examples, but yes, 4.9 and 4.10 are also.
And those are the ones in the bottom south
They're along Darby
western
Paoli
corner?
Road, yes.
Those are also front yard setback
Yes.
nonconformities? Okay.
Yes.
Now, you talked about the buffers from the R district. Does the plan show vegetation of them?
They are, our plans show that those areas are wooded along the border. Again, on my plan here, there's a large wooded area in the southeast corner along the east. There's a row of trees along Newtown Road. It's treed along there. So that area pretty much is mature tree plantings. There are some open areas, but for the most part, it's all vegetated.
And you're supposed to provide a landscape plan for that buffer area, correct?
As part of subdivision, preliminary final plan of subdivision, it's not required as part of conditional use.
Okay, so that,
I'm sorry.
sorry, let's move that over a little more. So that, what you're saying is yes, but that's at a,
That's at a later stage.
and that's as required by the ordinance.
Correct.
Let's talk about utilities on the site. Is there water available to the site?
There's an existing water main in Newtown Road that extends down beyond Abrams Lane from the east. There's existing water in Darby Paoli Road up to Godfrey. So water is available to the site.
And I'm showing you MT12. And what is that?
That was a letter we had received from Aqua Pennsylvania, the public water providers, saying that they can provide water to service, public water to service the site.
All right, for purposes of identification, this is a February 4, 2008 letter from Aqua Pennsylvania, Inc., addressed to Mr. Fiorello.
And how about sewer?
There is an existing sewer main that comes into the site that currently is serving the dairy barn. There's an existing sanitary sewer interceptor that runs down on the west side of Darby Paoli Road that parallels Darby Creek. And there's a current line that comes into the site from that interceptor line.
And did you prepare a feasibility study with respect to sewering this property?
Yes, we did.
And is that MT10?
Yes, it is.
And what does it conclude?
It concludes that we can provide gravity lines through this site to provide service to the site, to all the development.
Had you, in that study, also considered providing some non-public sewer to various types of lots?
One of the things that was considered is some of the large lots that I guess would be shown on the 64-lot option, which has the large 10-acre lots in the southwest corner of the site. The thought had been since they are such large lots, that they may be able to be served by on-site systems and not extend the public sewer to that point.
Are you allowed to do that under the,
Density modification requires public sewer for the entire site.
so that's what you're proposing?
Yes, we are.
Okay, now, under your sewer feasibility narrative, did you seek information with respect to the status of treatment capacity and conveyance capacity from this site to the treatment plant?
We contacted the downstream authorities relative to sewer availability. We got replies from a couple of them saying that, pending a formal application, they do have the capacity to service at this time.
Did any of them give you written statements to that effect?
We received letters from the Radnor Haverford Marple Sewer Authority and the Delaware County Regional Water Quality Control Authority.
Okay, and I've shown you Exhibit M13, which is a May 3rd letter to you from the Delaware County Regional Water Quality Control Authority. Is that the one you're talking about with respect to Delcora?
Yes.
And with respect to Radnor Haverford Marple, I've shown you MT14, which is a May 24, 2013 letter to you from the Radnor Haverford Marple Sewer Authority. Is that the one you're referring to there?
Yes, it is.
And the other authorities, the responses have been verbal?
I haven't really gotten any kind of response from them. They just, pending a formal request, no reply was given.
And at what point would you be making a formal request?
As part of our subdivision land development application, we would have to file the requisite planning modules and go through the approval process.
With respect to storm water management, what have you done with regard to the capacity of this site to handle storm water?
Well, first of all, we're trying to minimize the development, so we're trying to create a low-impact development by minimizing the amount of impervious cover on the site. But having said that, we know that the Township Stormwater Ordinance requires stormwater management as part of any development, and part of that requirement is the need for groundwater recharge to prove that we can put the water back into the ground. So we performed a number of percolation tests throughout the site to check soils and to check their permeability to make sure that we could provide the necessary recharge when the time came.
And you have done those tests?
Yes, we have.
And are the results of those tests included in the stormwater management feasibility narrative, which I gave you to look at as Exhibit MT11?
Yes, they are included in there.
So from an engineering standpoint, is this site capable of handling the stormwater requirements of both the state and the township?
I believe it is. We have to go through that final design as part of our land development process, but our preliminary investigations show that we don't anticipate any problems providing the required stormwater management.
Now, what would be your next step after conditional use approval?
Assuming we got conditional use approval, we would go into engineering design to do all the detailed design, setting grades, stormwater management, erosion controls, designing our sewer extensions, our utility work, and provide formal site development plans that would be submitted to the township for approval.
Are there items that are set forth in the density modification ordinance that are supposed to be complied with at subdivision approval as opposed to be shown as compliant at the time of conditional use application?
The conditional use ordinance more or less states that fully engineered plans aren't required. It's more or less a plan to show the intent, and it specifically states that engineered drawings aren't required. So we have shown in our submission the intent, which is basically the road layout, the general lot configuration, so that all the detailed design that's required as part of land development would be submitted at that time.
Okay. How about, for example, any additional plantings in the buffer zone?
Again, that's something for preliminary plan land development or subdivision at that time.
The nuts and bolts of your tree protection measures to be taken in your preservation and conservation?
Yes, that's
mode?
part of our erosion sediment control, our tree protection, and all the features that are required to protect the areas that we aren't developing and to control the areas that we are.
Okay. Just a couple of other interesting questions. Are you proposing street lighting in this development?
No, we are not.
The open space in the development, do you know who or what type of entity is intended to own the open space areas?
I think that's a question for Mr. Scott, and I believe it's, some type of an association that would be controlling the open areas and things like that.
Okay. Just 1 second. With respect to your plan set of 38 sheets,
Well, there are 40 if you count the extra 2 sheets, 10A and 11A.
okay, 40, and what you're saying is you would take the 38 sheets that are MT4 and take out the 10 sheets that are duplicated by, the 8 sheets that are duplicated by MT5 and add those 10 sheets.
Yes.
Do those sheets establish the ability to develop this plan in accordance with the ordinances of the township?
I believe they do, yes.
Okay. Are there areas that you would require waivers from the subdivision ordinance that have been shown as consistent with your waivers instead of consistent with the requirements of the ordinance?
Yes, there are a couple areas, because we're trying to develop this with a low-impact development, would require waivers from requirements of street widths, cul-de-sac lengths, the size of the cul-de-sac bulbs, and I believe they're the ones that I can remember off the top of my head.
Okay. Would you put up sheet 2 for a second? Now, when you talk about waivers on length of cul-de-sac, in particular, are you talking about the cul-de-sac on the northwestern end of the property?
Yes, what we would call is the Phase 3 cul-de-sac.
Okay, and that's longer than the ordinance, subdivision ordinance would permit?
That is correct.
Okay. If you were required to develop that consistent with the subdivision ordinance, could it be done?
It could be done. It would require another access point onto Newtown Road by bringing in some type of another spur, if you will, to come in and tie into the road there some point, that we would have a loop in the upper portion and a cul-de-sac length at the lower end that would be, that would meet the ordinance requirements.
Okay. And why didn't you do that?
We were trying to eliminate the number of entry points onto Newtown Road, and We feel that we can still provide access and servability to the lots in there without having to provide that second access.
Are you in the process of designing emergency access to the end of that cul-de-sac as well?
We're looking at that. We have a couple options that we're pursuing, and we'll probably have some information on that soon.
That would be a next hearing item.
Yes.
Okay. The area that you would have to come through to provide your second access, what is that area called?
That is called the rye field.
Is that considered to be of primary visual importance?
It's my understanding, yes. I think everybody has been talking about preserving that corner.
What is that the view shed of?
Basically, that's the view shed of pretty much, I would guess, the entry point coming into the township. You've got to remember that on the other side of Darby Paley Road, on the other side of Skunk Hollow, you're in Newtown Township. So this is one of the main entry points into Radnor Township from the west.
And what's the slope on that field?
That slope, while it is less than the 20% that is governed by the steep slope ordinance, the slope is, I'm going to say, in excess of 10%. It is a gentle sloping field, but it does have a lot of slopes to it, as it can be seen. If you can see the topography here, this area is sloped all the way, pretty much the whole field.
And which way, what's the direction of the slope?
It slopes at the high point up here through the site, and it slopes down towards the west, towards Darby Paley Road and Darby Creek.
So that when you're at the corner of Darby Paley Road and Newtown Road, you're looking out over that field as a major slope in front of you into the site.
That is correct.
And to provide that second access to shorten your cul-de-sac to 800 feet, you would have to bring a road in through that field?
Yes.
Are there other places, for example, where you have more than 3 lots on a private drive?
Yes, we do have in, if we can go back to sheet 1, where we have the option for 64 lots. In the west, I guess these lots numbered 4, 4, 4, 5, 4, 6, and 4, 7. There are 4 lots here sharing a common drive. Up in the Phase 1, Phase 2 corner, lots 1, 4, 1, 5, and 1, 6 share a drive also with lot 212. So there are 4 lots served by a common drive instead of the maximum 3. And again, down here in Phase 5, where we have the existing driveway that comes into the site, we're making use of that to serve 4 lots.
Now let me have your pointer. For example, on this one, why didn't you just bring the cul-de-sac in 1 more lot and then have 3 on it and put the cul-de-sac 1 lot further in to comply?
Again, we're trying to minimize the development and the disturbance. There is an existing farm road that comes down through this open area between the trees, and there is an area there where there's a couple existing farm buildings where it sort of made sense to provide a terminus to the roadway at that point.
Okay. So these are all places where you're accommodating the natural features and asking for a waiver, but could comply. Your plan isn't non-compliant because there is no way to comply.
That is correct.
So that if this conditional use was granted with the requirement that you not have more than 3 lots on a private drive, while you would not like that because of what it does to the natural features of the site, it would not prevent you from complying with that requirement.
That is correct.
And these are subdivision ordinance requirements.
Yes,
So they're waivable by the board.
Correct.
That's my questions of this witness.
Okay, very good. Before we go to cross, I must admit to a certain amount of confusion on the sheets that are going in and out of MT4 and MT5 and the relevance of all of that.
Let me suggest to you that we will bring a set that is correctly compiled. We did it this way simply because the application was made with 38 and then 10 replacement ones, but we can provide 38, actually 40 sheets in a compliant set, and we'll call that MT16.
All right, great. So that'll come in next, at
And
next hearing.
we'll give you that next time.
Okay, very good. All right, Mr. Rice, do you have any questions? We're going to go to, if it's 10 of 10 now, we have a couple of housekeeping issues. Are you going to go beyond 10?
I expect to go beyond 10.
Okay, then let's deal with a couple of housekeeping issues, and then maybe, rather than breaking you up in the middle of your cross-examination, we'll just have you start with cross-examination at the next hearing. With regard to the next hearing scheduling time, go off the record.
6:30?
6:30 rather than 7, to give us 3.5 hours. What do we have in terms of witnesses coming in yet, numbers of witnesses? And
I have two more plus Mr. Scott back for just some wrap-up questions. One of them will be pretty short. It's just the financial feasibility.
okay, and the other's
Traffic.
traffic, and that'll be fairly lengthy, I would assume. Okay. All right, so 6:30 is a better time. Does that work for you, members
That
of the
6:30 is
public?
fine.
Is that a problem if we make it at 6:30 instead of 7? I don't see any strong objection to that. All right, well, I think what we're going to do, rather than cutting up cross-examinations, we'll let all of those people who wish to cross-examine do so at our next hearing, and we will announce that now to occur on October, this is back on the record, I'm sorry. That's right. We will resume this hearing with the cross-examination of Mr. Fiorello's testimony on October 17, 2013, at 6:30 p.m. here in the hearing room in, well, we don't know that it's going to be in the hearing room, do we?
We have, I believe, two possibilities, either here or the roll call room.
All right, so either here in this hearing room or in the roll call room at 6:30 p.m. on the 17th. The township has asked that I issue further public notice in that regard, so there will be newspaper publication of that will appear for 2 successive weeks. And we will conclude this hearing this evening at this time. Thank you all very much for your attention and participation.
And both of those rooms are in this building.
Yes.